Under Article 2, a party may be totally or partially excused from performance. If a party's performance is excused, any resulting non-performance or delay won't result in a breach of contract. In this lesson, we'll discuss excuse due to impracticability of performance. Article 2 excuses a seller's non-delivery or late delivery if the seller's performance has been made impracticable by either the occurrence of a contingency or good faith compliance with a governmental regulation. Although Section 2(6)15 only explicitly excuses a seller's performance, the Code's official comments and many courts have indicated that the section may also excuse a buyer's performance. For a seller's performance to be excused due to the occurrence of a contingency, the non-occurrence of that contingency must have been a basic assumption on which the party's contract was made. Generally speaking, this means that the contingency wasn't reasonably foreseeable by the parties at the time the contract was made. Market-based price fluctuations, production cost increases, and supply failures are generally foreseeable contingencies for which the seller bears the risk. However, certain circumstances resulting in increased costs or supply issues, such as war or crop failure, may suffice to excuse the seller's performance. Let's consider a few examples. First, imagine a craft brewery contracted to sell a stated quantity of craft beer to a distributor over time at fixed prices. Shortly after contracting, various factors caused the production cost of beer to rise, including an increase in the cost of yeast and a sudden surge in market prices for packaging. Could the brewery claim impracticability of performance? No. For one, because the parties entered a fixed price contract, the brewery bore the risk of production cost increases. What is more, common cost increases, such as the increase in the cost of yeast and packaging, were foreseeable risks that don't furnish a basis to excuse the brewery's performance.